questions answered as well. And then here is Leighton's information, her phone number and her email address, so that we can get that taken care of. And just so I know that one of our attendees had asked if she could talk to Leighton later. And yes, if you would call her at 3 o'clock this afternoon, that would be fantastic. And just give her a call at the phone number listed. She would be more than happy to talk with you. So just maybe 1 or 2 more minutes and we can get started. So Leighton, I know that you are a graduate of U of A because of your birthplace outside of Tucson. You grew up on a farm, right? You're on mute, so you better unmute a little bit.
Yes, that's right. I was born and raised near Tucson, Arizona, and I did go to the U of A. So sorry, any ASU grads that might be in the chat, might be in the webinar today.
Okay, so also the chat, let's see, it should be, let's see, if you can, if the chat's not open, go ahead and use the question and answer. I think that I can see the chat. You might not see it yourself, but I can see the chat. Holly, let me know if you don't see the chat, but
I can see the chat.
Okay, you can?
Yep.
Can anybody else, can you see it or can you not see it? I can see the question and answer, so you may have to just ask the questions and answers. Okay, perfect. That is awesome. Okay, so it looks like the chat is disabled. So go ahead and use the question and answers, and we'll get those questions answered for you, because I can see the questions pop up. So, all right, so let's go ahead and get started. We've got lots and lots to talk about, and we will start with our first question, which is a trust the only way to avoid probate? Now, before I'm going to have Leighton answer this question, it probably would be a good idea to understand what the meaning of probate is. So probate describes a superior court proceeding where the court appoints a personal representative of the estate of a deceased person. The representative is responsible for paying the estate's debts and distributing any leftover assets. I know that has been a big question that I've always heard from people is, well, what really is probate? And I think that helps to understand what probate really is. It's just the court's way to determine who gets to decide what happens to the debts and assets of a deceased person. So going back to the question, Leighton, is a trust the only way to avoid having the court decide what happens?
So the answer is no. For the vast majority of people, a trust is indeed the better option, but you can avoid probate without a trust. So the key to avoiding probate is making sure that on your death, there's not one single solitary asset stuck in your individual name. Everything has beneficiaries listed, and so that upon your passing, those assets would transfer to the named beneficiary designated.
So when you say that, so if I have, let's say, I have a retirement account, as long as I have a beneficiary for that retirement account, but I don't have real estate or anything else, I have one retirement account, I don't have to go through probate as long as I have a beneficiary identified. Is that what you're saying?
Correct. The problem comes in with real estate, because of course it's easy for us to add beneficiaries on our bank accounts, our 401ks, but that's not the case for real property. So you actually have to do something, file a executed deed to convey the interest that you own in that piece of property to either named individuals or to your living revocable trust. So that's why in a lot of cases, real estate ends up triggering probate.
So that actually leads to another question. So you said triggering probate is, I mean, is there a certain level of assets that will trigger a probate? I mean, if you only have like $500, does that matter?
Mhm.
Like what's the
Yes,
deal there?
so it's sort of a two-pronged test. It's first assets or an asset stuck in a deceased person's name, no beneficiary listed, not in a trust. And
Okay.
then the second part to that test is the assets exceed $75,000 in value, and that's aggregate. That's not per asset. The other thing to note is that if one thing, let's say your house, you didn't have a beneficiary listed, it wasn't in a trust, that's not going to result in your entire estate having to go through probate. It's just probate for that specific asset that was left without any designated beneficiary.
Okay. So let's talk about specifically real estate. Is there a way to avoid having to get a trust that that basically you can somehow designate what happens to that if you pass away and you don't have a trust?
Absolutely. So if you don't have a trust, then you most certainly want to execute what's known as a beneficiary deed. So the beneficiary would convey the property effective upon your death to a beneficiary or to a number of beneficiaries. And so how that would be effectuated is your death certificate would then be recorded with the county, and then the property will automatically vest into the beneficiaries named under the beneficiary deed instrument.
So so obviously that's a fairly simple way to do it. And what about a will? Does a will determine, I mean, will that kind of, if I had a will and I said, okay, in my will, I'm going to give my real property to Holly because she's awesome, is that a way for me to transfer real property?
You can transfer real property through a will, but if you do that, then it's going to be subject to probate. So the will would be filed with the court and probate would have to be initiated, whereas the benefit of the beneficiary deed would avoid probate in the first place.
Oh, so the real property without a trust has to go through probate,
Unless
right?
you've executed a beneficiary deed, yes.
Unless I've been, okay,
Mhm.
got it.
So
Oh,
that's what
okay.
I mean by going back to the question. No, you don't have to have a trust in order to avoid probate. But if you own real estate, you'd have to execute a beneficiary deed, and then all of your accounts would have to specify beneficiaries, transfer on death, and those beneficiaries would all have to be living.
Okay, so that's another question. So let's say that so you said they have to, all of the beneficiaries have to be living. So, you know, I'm sure we're all perfect in every single way because I mean, I know that you are, and I know that of course Holly is. And so we have all executed, we've gone through every one of our bank accounts, we've gone through all our retirement accounts, all of our mutual funds, our stock portfolios, all those things, and we've executed, we've said, upon our death, these are all of our beneficiaries. And we've put in, you know, if we're not married, we put in our parents or we put in our siblings or whatever it is. But let's say that one of them has passed away, then at that point, does that trigger probate?
Potentially. And so that's where the trust would be a good bet to account for all of those what if scenarios and all of those contingencies. So you could specify that, you know, if you have everything titled in your trust, then you could really drill down into possible scenarios and contemplate, well, if one of my named beneficiaries pass away, then where do I want that deceased beneficiary's share to go? Instead of it either being left to the institution's policies, or in the event that option was up to you, maybe you forgot to indicate that on the, you know, on the online portal where you do your online banking. And so, no, you don't have to have a trust to avoid probate, but a trust really is the best bet in order to try and avoid probate at all costs.
So most of the time, and this kind of goes, I mean, it ties into the question, because in reality, the question that I get, and it may not be the question you get, but the question I get all the time is that, you know what, I don't really have a ton of money, at least in their own mind. They don't have a ton of money. I really don't need a trust. Either they're not married, or they have one piece of property and they maybe have a retirement account. But to me, that's really the perfect person that would need a trust. I mean, just because I know what a trust entails, wouldn't who do you think is the perfect person that a trust really encumbered? I mean, who would be the perfect person to say, you know
Yeah.
what, you really do need a trust?
So there's a common misconception that trusts are only for high net worth individuals, and that's not the case. Trusts are for anybody who has property, no matter the value, and who has loved ones or people that they care about and want to pass their assets to those individuals or those charitable organizations. So virtually everybody should have, at least, if not a trust, some sort of estate plan.
Okay. And what is the difference between a will and I mean, what would a will be different than a trust?
Mhm.
Because that's the other question is, well, why not? I have a will. What's the difference?
So there's two approaches you can take in terms of estate planning. You can have an estate plan where the main component is last will and testament, and then you have all of your ancillary documents, your healthcare powers of attorney, your financial powers of attorney, a living will, deeds for real property. Or the other option would be to have an estate plan where the main component is a living revocable trust, and in which case you still have those ancillary documents, which are very important, the powers of attorney, and then you would have deeds for real property to transfer the interest in that real property to the trust. The biggest distinction is really the trust is more comprehensive. So you can contemplate, like I said, all these what if scenarios, so that it should make things easier for you on the housekeeping side. So that as life happens and things change, you don't have to constantly update each individual account and the beneficiaries you've listed. You'd simply have to amend the trust.
Makes sense. And then you've got to fund the trust. You've got to make sure that they all have to go back into the trust.
Correct. Yep.
Okay, well, I think I've hammered you enough on this one. So let's move on to the next question. And
Okay,
if you do have questions, put them in the question and answer, and we'll try to get those answered at the end. So, okay, so we talked about what probate was. Number 2, does a living revocable trust protect your estate from creditors? Not predators, creditors. So I guess one
No,
and the
it
same.
does not protect your estate from either creditors or predators. And that's another common misconception is that, oh, I set up a trust, so it's giving me creditor protection. The only type of trust that gives you creditor protection are irrevocable trusts. And the biggest difference between a living revocable trust and an irrevocable trust is, well, one you can revoke and amend, and the other you can't. But mainly that in an irrevocable trust, the reason why it's giving you that creditor protection is because you've relinquished all control and access over the assets that you put into an irrevocable trust. So essentially you can say to a creditor, well, it's for my benefit, but I have no control over that account or those assets in the irrevocable trust. So that's what protects it from third parties. Because of that fairly big drawback, it's not practical for vast majority of people. What most people are talking about and are needing in terms of estate planning and is a living revocable trust, not an irrevocable trust.
Is there a time when, I mean, when you would really, because we don't see, actually, Yvette just asked this question, why would you do an irrevocable trust versus revocable? That's exactly my question is, when would you ever do an irrevocable? I don't see them hardly ever. Mostly I see the revocable ones.
So a lot of time, irrevocable trust can be common among doctors, for example, because there's a high probability that they're going to be sued at some point in their career. So they can set aside some assets and fund the irrevocable trust with those assets, in the hopes that they're not really going to need access to those accounts from on a day-to-day basis. But even then, that the big drawback of losing access control to those assets is a big one. So it doesn't, for that reason, it doesn't really make sense for the vast majority of people, and why you don't see them as frequently.
Yeah, that would make sense. Like I said, we rarely will see them. In fact, most mortgage companies will only do mortgages in living revocable trust, because you have to have the ability to move things in and out and have some control over them. So that would make sense. Along those lines, is there a reason why you would put your mortgage in a revocable trust? Not the house, not the actual deed, but is there a reason why you would put the actual mortgage in a revocable or a living revocable trust?
It would be very rare for that to make sense. And then the other big drawback of that was it would probably trigger the due on sale clause with your lender. So no, you're not going to do that in most cases.
Okay. And it's funny because we get asked that all the time, and we do them. It's kind of a double-edged sword as to why you would do your actual loan in the name of a trust, because for us it's actually the asset is what is going into the trust, which is the actual property, not the debt. And so that's kind of what I always tell people is you're putting the asset into the trust, not, you don't need to put the debt into the trust. So that's something that we run into quite a bit. So, but I was just wondering your question or your perspective on that. So, okay. Good question. So on question number 3, does your LLC or does my LLC, which holds my investment properties, need to be tied to my trust?
Yes. So going back to probate, if you have an LLC which holds investment properties and something happens to you, that LLC, if not tied to your estate plan, would require probate. So it's very important that if you have a business entity, you've drawn up the necessary paperwork to transfer your interest in that entity to your trust, or to set up the entity so that the member, in the case of an LLC, the membership interest is owned by you as trustee of your trust. Now, that doesn't undo the liability protection that the entity is providing you. It's solely for the purpose of making sure that that LLC won't have to go through probate, i.e. the houses that the LLC holds, bless you, wouldn't have to go through probate.
So, okay, so let me walk that back a little bit. So if I hold an investment property, and the whole reason that I'm holding the investment property as an LLC, that whole reason I'm doing that is because I want the protection from lawsuits or whatever, because it's an investment property, somebody slips and falls, they're going to sue me, right? So but I still want to hold that LLC and have it tied to my trust, because I want the protection, or I want the probate avoidance of that LLC, correct?
Correct, you got it.
Okay. So what I want to do is I want to make sure that one of the members of the LLC, or the membership of the LLC ownership, is the trust. Is that what you said? Oh, you turned on mute.
Sorry. So that's
That's
one
okay.
option, is to have
Okay.
the membership interest owned by you as trustee of your trust. And the other option, Arizona allows you to execute basically like a transfer on death for your LLC, so that the interest in that entity transfers on death to your trust.
Interesting. I think that's a really interesting thing, that because that's probably a 50-50 in how I see people hold that. I see more sophisticated borrowers doing that. And it's not so much sophisticated borrowers, more sophisticated accountants that do that, just because of asset protection. We see memberships and their LLCs being tied to the trust as we start backing out of those, who owns what. And that definitely, to me, that would definitely trigger ownership of a trust versus a will for sure, because it gets a little bit too complicated. But if you, because that's getting into ownership things, I would definitely suggest people talking to estate planning attorneys on things like that for sure. Okay, so let's go into question number 4. Can my successor trustee change the terms of my trust? So first of all,
No.
tell me what a successor trustee is.
Yes, so your successor trustee is basically the executor. So most people hear the term executor, and are more familiar with that term than perhaps a successor trustee or personal representative. But it's just jargon dependent on which document you're referring to. So in the context of a trust, the person who administers the trust estate is called your successor trustee.
Okay.
In the context of a will, the person that's administering the estate is in many states known as the executor, but Arizona uses the term personal representative. So their function is the same. Basically, they're gathering up all of the assets, liquidating things, and then making the ultimate distributions to your beneficiaries. I get this question all the time from clients. They want to know if their successor trustee has the ability to change the terms of the trust. And the answer is no. Only you have the authority to change the terms of your trust, which is a good thing. So upon your incapacity, so during your life, while you're alive, you have all your marbles, you can fully amend and revoke and do whatever you want with your trust, move assets in and out, you have full control. Nobody else has power. And then upon your incapacity, that's when your successor trustee would be able to step in and administer the trust estate, still for your benefit because you're alive. And then upon your death, then they'll continue administering the estate and then distributing what's left of it to the beneficiaries that you designate in the trust document.
So you can actually have, as a part of the estate plan, because this is a trust that happens while you're still living, at some point you may become incapacitated. And so there's a part of the plan that's going to tell what happens if that occurs, correct?
Correct.
And so this becomes part of that piece as well, correct?
Correct.
So that's where this concern occurs, is if I'm incapacitated, can the successor trustee change some of the, what I really want to have happen?
No, they won't have any, they have authority to manage the trust estate, but as soon as you are deemed incapacitated, then the trust becomes irrevocable. So the terms would be set in stone, and all the trustee can do is administer the trust pursuant to how it's currently laid out, but they cannot make any changes to who's appointed as trustee, who the beneficiaries are, to the distribution scheme. It's set in stone at the point of incapacity.
Okay.
And I think we got a question in the chat. Can a spouse
Yes.
change the trust prior to death? So that's classic attorney answer. It depends. If you have a trust that does not become, no portion of the trust becomes irrevocable on the death of the first spouse, then yes, the spouse has the ability to change the terms of the trust. And that's usually the case. Most people's trust, I would say the vast majority are trusts in which the spouse has the authority to change the trust, at least in some way. If not full authority to change the trust whole, in full.
So do you ever see spouses have separate trusts?
Mhm.
So
Yes,
like
definitely.
one where one spouse has certain, because as I'm thinking about this, one spouse might have certain assets that they have under their name, like let's say retirement accounts, things like that they have under their name. So they have a trust for that. Then they have another trust for the other spouse where they have things. Is there a benefit for that, or is there I mean,
Yeah.
why would they do that?
The reason why spouses might have their own respective separate trusts is because they want to maintain certain property as their separate property. So because Arizona is a community property state, if you want to distinguish certain property, let's say inheritance, for example, or property that you brought into the marriage, let's say in the case of blended family scenarios, you're coming into the marriage with your respective children and you'd like to ensure that assets pass no matter what, without a doubt, if something happens to you, that assets pass to your respective kids, then you might want to maintain a separate trust to accomplish those goals.
Interesting. So, and so if, okay, so let's say that both spouses pass and your successor trustee, I guess it's not a successor trustee anymore. It becomes is it a beneficiary, or does it go down? Is that what that's called?
Are you
Is it?
talking about the people that are going to inherit these
Yes.
assets? Yeah,
Yes.
the beneficiaries.
Yeah. They can't change anything, correct? They just
Correct.
have to execute whatever, because at that point there's no changing. It's just whatever's happening, whatever has been set in stone by the trust.
Correct. Mhm.
Okay. I just have this weird scenario going on and that I know of that I'm trying to think through
Uh-huh.
without saying anything that's that's specific enough. So anyway, okay. Let's go on to the last question, and then we're going to get into some bonus questions. So, question number 5. Are beneficiaries entitled to notice of changes to my estate plan?
No, they are not. And that's a good thing. This is a question I get quite often. People ask, do the people that are going to be responsible for taking action on my behalf, my powers of attorney, or people that are going to be inheriting my property, do they need to sign anything? Do they have to be notified when I update my documents? And the answer is no. So keep in mind that you're the owner of your assets, of course, and the people that you want to transfer your assets to only have a vested interest, a contingent interest. So their interest isn't vested until you pass away, because you can change it up until the point of death. So there's no need for you to notify anybody when you make changes to the plan.
So that's interesting, because I know that when we set up our trust, there's just times when you like certain kids better. So I'm just kidding. So obviously you can change things at any time, set up percentages, set up different ways. You can also, based upon what we had talked about when we were setting up ours, you can also set up um, timing of distributions, correct? You can
Correct.
set up, okay, at this point, I mean, obviously, if you have a minor and you happen to pass, you're not going to want your entire estate to go to that minor and say, oh yeah, have a great time, have a big party. You can set up timelines as well, correct?
Correct. Mm-hmm.
So those things are important, to know that you can set up your estate plan and change your estate plan, which is probably important to kind of review that plan, over time as things change in your life, correct?
Correct. Yes, it's very important. So you don't set up an estate plan with the idea that this is it, this is the final version. Life changes, things happen, and so it's going to evolve with those changes in circumstances.
So,
So it does require maintenance.
yeah,
For
that's what
sure.
I would say. I mean, I would guess some of the things that would trigger some of those changes. I mean, obviously, death or divorce, marriage or remarriages, things like that. What are some other things that you see triggering some changes to your estate plan?
I would say those are the biggest, death, divorce, the birth of a new child. If you want to change agents, maybe not necessarily of, due to death, but because feel like somebody else would be better equipped to handle a specific responsibility. Um, yeah, those are the biggest ones, I'd say. As
Okay.
any life changes, you should at least dust off the plan and make sure that it's still making sense for you.
Okay. And in terms of now, I know when we've set up ours, there are specific things that a lot of people don't realize that go into some of the estate planning documents, that you made us very aware of, which was very helpful. Um, Things like powers of attorney that, obviously you have medical powers of attorney, but one of those medical powers of attorney that we weren't aware of until we talked with you was, your children. When your children turn 18, you no longer have the authority to really know anything about them medically. Talk to me a little bit about that.
Yeah. So as our children become adults, they're still, of course, young adults, maybe children in our minds, but legally they're adults. So you wouldn't have to, if there was a medical emergency and they were in the hospital, just because you're their parent, their mom or dad, doesn't mean that you have the ability to communicate with doctors, make decisions regarding your care, because they're no longer a minor. So it's important, especially, I always recommend that my clients who are sending kids off to college or their kids just turned 18, that their kids should execute powers of attorney so that if, God forbid, something were to happen, their parents would have the ability to take action on their behalf, pay bills, talk with doctors, make decisions regarding their care.
And that was scary for me because um, as my daughter turned 18, it was like the first week of her senior year. And so if anything would have happened to her at school or anything like that, she's an adult in the school district's eyes. That meant that a phone call to me meant, oh, by the way, your daughter has been sent to the hospital, period. That's it. That's all I got. That would have been the only thing that would have been sent to me without a medical power of attorney because she is an adult. And that was a scary, eye-opening thing for me. Um, that especially when you have kids going to college, those are also big life things that you don't think of without having those estate planning documents executed. And they always say those things happen. You only think about those things after the fact and not when you're needing to have those things.
Right.
Another thing that we have a special needs daughter, and one of the things that also goes into an estate plan is setting up special needs trusts, which is different than a specific trust. Tell me a little bit about that.
Yeah, anytime you have a beneficiary who has special needs and is receiving or is entitled to receive benefits from the government for those special needs, you want to protect their eligibility to receive those benefits. So the threshold is extremely low. If they were to inherit from your estate, then more likely than not, they'd be disqualified from being able to receive those benefits. So the special needs sub-trusts or supplemental needs trusts, as they're often called, would accomplish the goal of making sure that they don't get disqualified from important benefits.
And those are definitely things that that are important to know, but most people don't think of when talking about trust. They think about, oh, here's how much money I have, and here's this, and then they just, those just aren't things that are talked about enough to be made aware that they're things that need to occur or need to be known of in a trust. So even though we are done with the top 5, there are some things, because this is very real estate related, I wanted to add a couple of real estate specific topics as bonuses. We talked a little bit about them, but I wanted to specifically talk about deeds. The real estate transfer of deeds, or the transfer of property through deeds, is so important, and these are the things that I end up dealing with quite a bit, because of errors made um, in the execution of deeds throughout a transaction. And it's either done because people don't pay attention, they expect somebody else to do it accurately, they think somebody has done it when they haven't, or they are just so ready just to have it done just to get the transaction closed, or they've set up their trust and they didn't follow through with what the attorney said and didn't finish the execution of everything. There's just so many things that happen that are super important to be aware of. So I wanted to talk about community property. We are a community property state. But there's these letters after, and if anybody's in real estate, you probably know what WROS means, which is with rights of survivorship. Leighton, can you tell me what with rights of survivorship means from a legal perspective? Oh, you're on mute again.
Sorry. So community property with rights of survivorship means that if one of the co-owners passes away, the interest that deceased owner has in that property automatically transfers to the surviving owner. So
Okay.
that's key. You want, in most cases,
Super key. Super key. Go ahead.
You want to always make sure that with rights of survivorship is tagged on there on your deed. If that is the result that you'd want to see. If something happens to you, you want the entire property to pass to your spouse or your partner, then you need to have the deed set up so that you hold the interest as community property or joint tenants with rights of survivorship.
So what happens if it does not say with rights of survivorship?
Then it defaults to what's known as tenants in common. So the difference in outcome would be when you are tenants in common, then the deceased owner's share reverts to the deceased owner's heirs. So that means that the surviving owner now owns the property with the deceased owner's heirs, which often is very problematic.
And I'm really glad that you said it that way, because it's not always an assumed. You specifically have to take title with rights of survivorship, because it is an option to not take title that way on property. It's not an assumption that you take title as community properties with rights of survivorship. It is an option to take title as community properties, period, or joint tenants, period. It is an option to take it with rights of survivorship. So if people don't understand the difference of that, they won't understand that if the other owner dies, it's not just a tax difference. Like, people always say, oh, the difference, what community property means is that there's a tax benefit when you go and deal with your estate taxes. It's not just that. The community property, the piece that's important when you're dealing with a state, is that with rights of survivorship, because of what happens when someone passes. Because, like Leighton says, the property becomes a tenants in common, where if you are not with rights or survivorship, you only basically own half of that property. The person that's remaining, the other side of that property is owned by the heirs. Now, you may be the heir, depending upon how that person owns it, but if you're not, the heirs own the other portion of that property. And again, I don't think in real estate we focus enough to make sure people or buyers or people like that understand and really know what that means. It's because it's just thrown around so nonchalantly. So what is joint tenancy compared to community property, or joint tenancy versus tenants in common?
So in joint tenancy, you want the same. The key is you really want the with rights of survivorship. So the difference between the two is the community property obviously establishes that it's between a married couple. So if you want your co-owner, whether that's your spouse or your partner or your family member, and you want your share to pass down to your surviving owner, then it needs to be held as joint tenants with rights of survivorship.
Correct. Which is exactly the point, is you really need to understand what those mean so that you know how the property is going to change hands upon someone's death. We talked a little bit about a beneficiary deed. How hard is that to file, Leighton?
Not hard at all. I don't ever recommend. It's fairly common. People think, well, it's a deed, it looks fairly simple. I'm going to just do it myself, or I'll go down to a title company. I'll have them prepare the deed. I never recommend that. The costs for deeds are fairly nominal. A few $100 to save yourself potentially thousands of dollars in probate if the preparer of that deed or you get it wrong. So it's a very technical document, and so you want to make sure that it's done properly and that you know the implications of how you've taken title.
Absolutely. Disclaimer deeds we deal with all the time. People want to buy, so a disclaimer deed, as most of you probably know, it says you're married. Because we're a community property state, you have to purchase, if you're married, you have to purchase a property, and then if you're only buying it as an individual, sole and separate, the married spouse that's not purchasing has to issue what's called a disclaimer deed, meaning that they're disclaiming their rights to that property, and which we do all the time. It occurs all the time. The problem is that once you've disclaimed it, very often they forget to non-disclaim it. If they're truly wanting ownership in that property, they're disclaiming it for some reason, one way or the other. If you don't forget that that's been disclaimed, if you're going back and setting up a trust, making sure you go back and put that property back into the trust, making sure that you're doing all those things, don't forget that that property has been disclaimed, because if something happens, even if you're married and you're living in the house and all those things, if you've disclaimed the property, if the surviving spouse has disclaimed the property, what would happen, Leighton?
You have no
there you
interest
go.
in it.
Yeah,
So
right.
yes, that's super important that if you, for whatever reason, let's say that you disclaimed interest in the property for the mortgage purposes. And then after the fact, you had intended on transferring it to your joint names and you're a married couple. It would be super important for you to make sure that you, like Amy says, that you undo that disclaimer. Otherwise, you're relinquishing all of your interest through that disclaimer deed.
Right. So we also deal with marriage versus cohabitation quite a bit. We get people that are married, great, however you want to take title, that's great. But we also get the scenarios a lot where we have people that, whether the cohabitation is roommates or domestic partnerships or friends and or families or whatever it is, and one is bringing to the table, let's say, the down payment. They're putting in the down payment, but they, for some reason, their credit isn't good or whatever it is, they're not going on the loan, they're not going on the deed, whatever the reason is, but they're living there, they're making payments. But let's say that the person that has the ownership or is on the deed for some reason, and you never got around to changing that deed, even though there was an agreement somewhere, who knows where, if it was in an oral agreement, whatever it might have been, that the person that is cohabitating has some sort of an ownership in that property. What happens if the person who is on the deed passes?
So if you have a domestic partner and you're not legally married, you have no protection. So it's super important that if you have a domestic partner, that you own a home together, that you've executed estate planning documents to effectuate what you'd want to happen if something happens to one of you. Because if you had no documents in place, then the laws of intestate succession, intestate just denotes that you passed away without any estate planning documents. So in that case, then your estate would pass pursuant to Arizona law. But you would have no rights to your deceased partner's estate as their domestic partner. So it'd be very important that if you're not legally married, you own property together, you have joint assets, you really need to have your estate planning documents done, because you'll have no protection under the law otherwise.
And I have been involved in a lot of those situations, and they're sad and they're very complicated, and they don't ever end up great. So make sure that in any type of advice to your clients when you're dealing with real estate, always have, the suggestion is always to either talk to an attorney or put it in some sort of writing, because there's got to be some sort of indication of what the expectation is. Let's talk about tax implications. So inheritance, the estate plan was executed, there is an estate plan, and you are the recipient of the inheritance. A lot of people seem to think that, we're just going to disperse, and all of the disbursement just is going to occur, and we're going to sell all the properties, we're going to sell all the assets. But there needs to be some sort of indication that it is super important to talk to someone about tax implications. Leighton, don't you give that advice as well?
Yes. So as part of the estate plan, I'm not qualified to dispense tax advice, but it is really important consideration when kind of implementing the strategy. So I always recommend that you have a CPA, that you have a good relationship with that person, so that you can get tax advice from that person, right, to assist you in formulating a plan.
And it's not only just tax advice, financial planning is super important as well, because there's often ways to lessen tax burdens. One question I did want to ask you, Leighton, was what is the on inheritance? How does that what implication does inheritance have on community property?
So generally speaking, inheritance is considered separate property. However, what matters is how you treat that inheritance, how you behave after you inherit that property. So if you take that inheritance and you commingle it with your community property to the point where it's indistinguishable as your separate property, then it loses its status as your separate property, and it's now community property, and then your spouse would be entitled to half. So it's super important that if you want to preserve inheritance or any other separate property as your separate property, you set it up in such a way that it would be, it's clearly identifiable as your separate property. You didn't take that money, dump it in your joint brokerage account, to which your spouse has access to, and is, prior to the divorce proceedings, they would regularly dip into that account for payment of household expenses and things like that, so that a judge, once it comes before a judge, they can't tell that it was separate property, because the way that you treated it as community property. So a lot of people have the misconception that, well, I inherited it, so I should be able to segregate that off and my spouse wouldn't have any right to it. But that's not the case. If you inherit it and you behave and treat it as community property, well, then it's going to become community property.
That's a great way to answer that. And then lastly, multi-state property ownership. We run into this a lot because we have a lot of people that own second homes here. We have a lot of people that relocate here. One thing that I notice a lot in multi-state property issues is that, let's say that we have a client that has their estate plan is done in a separate, let's say Wisconsin, okay? It's done in Wisconsin, and they have their estate plan done there, but then they buy property in Arizona. Their estate plan is done in a state that's not a community property. They use, lenders or, people that are not familiar necessarily with community property laws and things like that. And, or their attorneys are not familiar with with documents, executing documents in a community property state. We have run into problems, or we've had clients that have run into problems where documents have not been executed accurately, with things like with rights of survivorship language added, or titling property inaccurately, or because maybe they've done wills in another state rather than a trust, and we've had them having to go through probate here because of that. Do you run into that quite a bit?
Oh yeah, that's pretty common. So when we're talking about out of state property ownership, you want to make sure that the person, the attorney, preferably that you hire to take care of that property, to transfer it to your trust or title it appropriately, however you want the outcome to be, that they're licensed in that state, so that they know, to avoid those defects that we talked about earlier, and not, it's a simple omission of that key term with rights of survivorship would be a fairly big blunder that has, pretty massive implications in terms of your rights to that property. So you don't have your Wisconsin attorney prepare the deed for your, Arizona property.
Right. And we, like I said, we run into that quite a bit, where titling becomes an issue. So that is a big issue. But if does anybody else have any questions? I don't see any other questions in the chat or in the question and answers. We've covered a lot today. I know that Leighton is amazing personally, because I think I've been dealing with her for several years and I know her personally, and she is amazing. And I would be absolutely 100% like confident in referring her to all of my clients. I'm going to put her contact information up here again, so that if you have someone or have a client that you would like to refer to her, I would highly suggest you do that. Or if you want to have her review your documents and maybe have her take a look at your own estate planning documents, it would definitely be something that would be worthwhile. Again, I appreciate everyone attending. We will be getting this up on our YouTube channel and get a copy of the recording out to you. We will have our next top 5 webinar on the second Tuesday of next month. And I again thank everyone for joining us. I really appreciate the support. And Leighton, I cannot thank you enough. You are amazing.
Amy, thank you.
And
Thank you for having me. It was a pleasure to be here. Thank you, everybody, for attending. Hopefully you took away some important information to help you moving forward.
You are wonderful. Thanks so much, Leighton. Appreciate it.
Thanks,
And thank
Amy.
everybody for joining. We'll
Have a
talk
good
soon.
day. Thanks,
Bye-bye.
Holly.
Thanks, guys. You guys are amazing.
Bye-bye.